Good afternoon, everyone. I'm Stephen Pike, and I'll be moderating our session today. A practical update on reporting under the Fighting Against Forced Labor and Child Labor in Supply Chains Act. I'm delighted that you could join us for today's webinar and look forward to introducing you to our two guests who have joined us to add their insights and perspectives and provide context for our discussion of this legislation. Let me introduce you to Senator Julie Miville-Dechêne. She was appointed to the Senate in June 2018 after a successful career in the public service sector. She spent 25 years working as a reporter and foreign correspondent for Radio-Canada, and in 2007, she became the first woman ombudsman of Radio-Canada. Since her appointment to the Senate, in addition to Bill S-211, the legislation we'll talk about today, she introduced Bill S-210 that would require the implementation of age verification methods to protect minors from exposure to online pornography. She's also vice chair of the Standing Senate Committee on Transport and Communications, and co-chair of the All-Party Parliamentary Group to End Modern Slavery and Human Trafficking. Our other guest is the Honourable John McKay, Member of Parliament for Scarborough-Guildwood here in Toronto. He was first elected to the House of Commons in 1997, and since then he has served in a number of different roles, including co-chair of the Canada-US Interparliamentary Group. John was the sponsor of C-423, Canada's Modern Slavery Act, that was introduced in the House of Commons in 2018, and it was a predecessor of Bill S-211. Bill S-211 was passed unanimously in the Senate on April 23rd, 2022, and ultimately passed in the House of Commons on May 3, 2023, with support from both the government and the official opposition. Welcome, Julie and John.
Thank you, Stephen.
We'll be talking about the Fighting Against Forced Labor and Child Labor in Supply Chains Act for the next little while. And if I can, I'd like to just refer to it as the Supply Chains Act. By way of some practical insights and practical update on reporting under the Supply Chains Act, I want to share with you a practical approach to reporting under the Act that has found to be very helpful in many circumstances. So rather than looking at the Act and its statutory disclosure requirements as sort of a disconnected list that you have to work through, I find that from time to time, we can look at it through a different lens, one where we divide the statutory disclosure into three components. You remember that the report that's prepared and filed under the Supply Chains Act is retrospective, so it's looking backwards at what the business did in its most recent financial year. So in terms of a different approach, let's look at the three components. So the first component I call the factual information component, and that includes the disclosure of the entity's structure, activities, and supply chains, its policies and due diligence processes in relation to forced labor and child labor, and the training provided to employees on forced labor and child labor. So this is objective information, it's factual, and it occurred in the business's most recent financial year. The second component would be the remediation component. In other words, providing remedy for an adverse human rights impact. So in the circumstances where there's been an adverse human rights impact, the question is, what remedy was provided? So that would include any measures taken by the entity to remediate any forced labor or child labor, any measures taken by the entity to remediate the loss of income to the most vulnerable families that results from any measures taken to eliminate the use of forced labor or child labor in its activities and supply chains. So the remediation component is retrospective, and it will only be there'll only be disclosure under that if there's been an adverse human rights impact. Otherwise, the response is generally that it's not applicable and no measures were taken. The third component is one that's most challenging. It's the risk component. Let me walk through it. So the steps that the entity has taken during its previous financial year to prevent and reduce the risk that forced labor or child labor is used at any step of the production of goods in Canada or elsewhere by the entity, or of goods imported into Canada by the entity. This is the risk mitigation question. What have you done to prevent or reduce the risk? In other words, to mitigate the risk of forced labor and child labor. The second piece is the parts of its business and supply chain that carry a risk of forced labor or child labor being used, and the steps it's taken to assess and manage that risk. So I just explained the risk mitigation question. This is the risk management question. The next piece is how the entity assesses its effectiveness in ensuring that forced labor and child labor are not being used in its business and supply chains. And the effectiveness question is in many circumstances the most challenging of the disclosure questions. And you might pose the question, is your anti-forced labor and anti-child labor compliance program designed, implemented, resourced, operated, reviewed, tested, and updated in a manner that successfully identifies, assesses, manages, and mitigates the risks of forced labor or child labor in your business operations and supply chain? So it's risk mitigation, risk management, and then effectiveness of your compliance program. So I thought that would be, in many circumstances, a practical way to approach reporting. The next things I'd like to talk about for a few minutes would be issues that came up in year one, uh, items that are still or have been a challenge for many reporting entities and entities that are not going to report, um, how they're dealing with them. So not every issue, I can't deal with every issue in our short period of time, but I'll try and address a few. So number one, don't forget your business has 3 deliverables. One, file a board-approved compliant report with Public Safety Canada. 2, complete the questionnaire. And 3, post the report in a prominent place on your website. Unless you successfully complete all 3 of those deliverables, you will not have complied with the Act if you're a reporting entity. The updated guidance. As many of you know, the Public Safety Canada has published various iterations of guidance. The most recent was modified on March 10th, 2025. And the most material change or amendments to the guidance were published in November 2024. According to Public Safety Canada, the guidance and the information on the Public Safety Canada website should not be considered binding or as legal advice. Well, more about that shortly. The questionnaire. The questionnaire is mandatory, and all fields have to be completed if it's going to be acceptable to Public Safety Canada. And you should make sure that your team definitely downloads a copy of your responses to the questionnaire before they exit the Public Safety Canada portal. Prior year reports. Reporting entities are required under the law to post their most recent report in a prominent place on their website after it's been filed with Public Safety Canada. Reporting entities are not required to continue to post last year's report, although Public Safety Canada encourages reporting entities to keep prior year reports posted. So it's really up to the reporting entity if they want to keep last year's report up. Just so you know, Public Safety Canada is currently posting in its online catalog both 2024 and 2025 reports. So those reports are going to be available to the public regardless of what you're doing on your website. The attestation, this has caused a lot of challenges for many businesses. The attestation must be approved still by the governing body of the reporting entity, generally the board of directors. And while Public Safety Canada has published a suggested form of attestation, use of the form is not mandatory. What is mandatory is that the board has to approve the report, and it must be evidenced by a statement that sets out whether it was approved pursuant to certain subparagraphs in the Act, which are 11.4A, 11.4B1, and 11.4B2. And it has to be signed by a member of the governing body, together with the full name, title, and signatory and date of signing and signature of the member of the governing body. And they also have to put in a statement that I have authority to bind ABC Corp. One more question here is the question of goods. This was an important change reflected in the guidance published by Public Safety Canada in November 24. And the current interpretation is that goods refer to tangible physical property that's the subject of trade or commerce. So looking at things like real property or electricity or software or insurance are excluded. So in terms of determining what you're importing or producing, it's only tangible physical property that's of concern. Similarly, in the definition of entity, and by the way, every time you see the word entity in the Act, it's referring to the defined term entity, not sort of a generic enterprise. It's only businesses that meet that definition. So, and one thing that the guidance also sets out in the most recent its most recent iteration is that if a subsidiary does not meet the definition of entity, it would not have to report, even if the parent company is reporting. So the definition of entity is critical. And also just refer to Part 2 of the Act, which is called Reporting Obligations, Entities. And that part applies to any entity producing, selling, or distributing goods in Canada, importing goods into Canada, or controlling an entity that engages in any of those business activities. According to Public Safety Canada's November 2024 guidance, entities solely involved in distributing and selling are not expected to report under the Act. Public Safety Canada will not seek enforcement action in those instances. Trying to put together or combine that statement from Public Safety Canada with Section 9A of the Act it's hard to find out how these would fit together. I go back to the comment that the guidance is, according to Public Safety Canada, not legal advice. It's something to be considered very carefully in terms of whether your entity, assuming it's an entity, will have to report, and the balancing of Public Safety Canada's guidance with the statutory requirement that reporting is required. I'd like to now turn things over to Julie Miville-Dechêne, Senator Miville-Dechêne.
Thank you very much, Stephen, for inviting me and for your explanations. I will try to not repeat different things, but please bear with me. So on the planet, 27.5 million people are victims of forced labor, 12% of whom are children, and this trend is rising. Canadians, so all of us, consume $48 billion worth of product at risk of containing forced labor yearly. So my point of view on this, We, and obviously companies are included, must fight against this blatant violation of human rights in which we are complicit. Canadians consume products made by slaves. The race for low price come at a great human cost. When your teenager finds a dress for $5, it's worth asking questions. Yes, developed countries are at risk, are most at risk, but not exclusively, as shown by the massive scandal involving the fast fashion companies Boohoo in the UK. The company paid its workers, many of them immigrants, a third or even a quarter of the minimum wage and forced them to work excessive long hours. And Canada is not beyond suspicion either, particularly when it comes to the exploitation of temporary foreign workers with closed work permits. So, according to public security estimates, S211 requires between 5,000 and 10,000 medium and large companies operating in Canada to publicly report once a year on the risk of forced labor and child labor in their supply chains. Penalties are in place for false or misleading statements, but let me clarify, the requirement is to honestly, and I insist on honestly, report on efforts made, not to eliminate forced labor from the supply chain. Of course, diminishing forced labor is my hope, but it's not a legal obligation under the Act. However, investors and civil society are watching you. As one of the two sponsors of this bill, I'm very aware that you had only guidelines and not detailed regulations to help you file your first and second report. I have heard legitimate complaints about the lack of clarity. As a senator and co-sponsor of S211, I've not been informed or involved in any consultation after the adoption of the bill. So this latest change in the scope of the bill in the guidelines was obviously news to me. And I think Stephen is right to be very prudent, because when you read the bill, it seems that the scope was very clear and was larger than it is now in the guidance. So in 2 months, Canadian business that meets the threshold have to file a second annual report detailing forced and child labor risk in their supply chain, and especially the process in place to address and minimize these risks. These have been lacking in many reports. In the first year, we saw already different business having different approaches depending on site, their industry, business, risk tolerance, and brand. So this is normal, and there's not one size fits all. The idea, as Stephen said, is to answer every question. Bill provides details on what must be included in the report. The goal is to avoid a simple tick the box exercise. I was asked recently if entities could file pretty much the same report this year than last year. I suppose they could, but what would it look like? Cut and paste, no follow-up, no improvement. And at the end of the day, the spirit of the law is not taken seriously. If the spirit of the law is not taken seriously, a stronger due diligence law will be contemplated by future governments. For big business with international presence, S211 did not mean a big change in the first year. They had the expertise and the resources to do the reports. Our law has a lot in common with UK and Australia and share features of other European statutes. Bill S211 is not as broad and demanding as due diligence law. I would add that Australia has developed a pretty good step-by-step handbook with a lot of examples for companies on its modern slavery law that was adopted in 2018. I would say that it's worth consulting. I've had a look at it, and it's really good for entities who have not much experience in such an exercise. It's not the same law exactly, but many criteria for reporting are the same. And it's very practical. I'll give you an example. In the Australian handbook, answers that are not acceptable. Two examples. Example one, this is the sentence you should not write. We have not taken any actions to assess or address modern slavery risk, as we do not have any risks. Not a good answer. Example two, our internal due diligence procedure, which has been in place since their creation in 2010, ensure there are no modern slavery risks in our operation or supply chain. So obviously, when you hear those answers, you know you do not. If you say that, it's not serious. You know, you have to go a little deeper. Obviously, if you don't answer at all a question, this is not the way to do it either. So, in closing, companies can choose to stay ahead of the curve and minimize risks by adopting exemplary practices. I would say an authentic commitment to the law is imperative and beneficial for three reasons. For ethical reasons, we've talked about that at the beginning. Who wants to be seen as hiring slaves? What kind of image this gives you? Also, companies want to maintain its global reputation. We hear here, name and shame. Obviously, you have reporters, you have investors, you have a lot of people looking at you. And finally, we want to ensure fair competition. As John used to say to me often, nobody can compete with the companies using slaves. So on that, I'll leave my colleague John McKay add some remarks.
Okay. Stephen, do you just want me to plow ahead here?
Yes, please go
Okay.
ahead, John. Thank you.
Thank you, Stephen. And first of all, let me acknowledge that Stephen has been a tremendous help to both Julie and I over the course of our journey on this bill. I'm a lawyer, but a recovering lawyer. And Julie is a journalist, and so we've particularly appreciated Stephen, your help, and we particularly appreciate you watching how this bill is being applied, because that is frankly a bit beyond our abilities to recognize. And Julie has gone kind of where we've been. I'm going to emphasize or talk about where we're going. In the words of that great Canadian philosopher, Wayne Gretzky, it's not where the puck is, it's where the puck's going. Mind you, I don't know how much of a great Canadian philosopher he is any longer, but since he's having his challenges. I asked a series of 6 questions to the bureaucrats through the minister. And the answers to the questions were, I thought, in some respects, quite revealing. I have to say that this is a private member's bill. It's an extraordinary thing to get any kind of private member's bill to royal assent, and it's extraordinarily difficult to get a private member's bill which has got such substance and consequential implications to royal assent. And I have to say that in that respect, the bill is a bit of an orphan bill in that it's not a government-initiated bill. And even at the point of implementation, they were begging us to put off the implementation for a year. And we resisted those entreaties. And as a consequence, we do actually now have a year under our belt, which I think has been somewhat insightful, but not maybe as insightful or as enthusiastic as we who've been in the trenches for a while would like it to be. I'd also point out that to Julie's point on tick the box or, gee, I got to comply, blah, blah, blah. This is a transparency bill on steroids. But think about the political environment. Prime Minister Carney just completed his first call with President Trump, and how long it will remain at a constructive or productive or civil remains to be seen. But the conclusion of the call was that we are moving much more quickly to a renegotiation of CUSMA. And inside the CUSMA is a paragraph with respect to slave products and the movement of slave products between countries. I would expect that the Americans are going to put that in a very significant position on the negotiation list. And I don't know that we actually have much of a story to tell other than S211, which is a transparency bill on steroids. But I don't think the Americans will be too impressed by our level of aggression in terms of enforcement. So I would be giving general advice. I would be paying attention to what your counsel says and not only fulfilling the obligations of the law, but the letter of the law as well, the substance and the letter of the law, because I think it will increase. The obligations will increase over time. So I asked a number of, as I said, 6 questions, and how many entities should have filed. And the answer I received, about 6,000 did file, but they really don't have a good answer on how many should have filed. The vague answer is somewhere between 5,000 and 10,000, which is maybe not as precise as one would like, but I think that number will get tightened down over time. I asked for an analysis beyond the minister's report that was filed in September, and received the answer that they're concerned about what remedial actions may be taken. Again, that's a bit of a vagueness on the answer. On how many government entities should have filed, their estimate is 350, and they received reports from 145. So government entities need to get to the point where it's not do as I say, but do as I do. And I don't think the government entities are exactly leading the charge here. Similarly with stock, there's a definite number of stock exchange companies. It's a finite number. Again, the numbers that filed were not maybe as robust as they should have been. I just want to end up with the final point, which was the final question, which was given the changes at the border and how many seizures have been made of forced labor products. So the answer was actually, I thought, quite revealing and discouraging. In 2021, CBSA carried out their first test pilot and detained 1 shipment, and which was subsequently released. They then changed their processes, and in 2023, intercepted 10. 6 were put under customs control, monitored and exported out of Canada. 3 were released after further supply information, and one was abandoned by the importer. In 2024, 33 shipments were intercepted. Additional supply chain information was requested. 32 were released based on the information provided by the importer, and one shipment was seized and determined to have had slave products in them. This doesn't live in the same universe as the number of seizures made by the Americans at their borders. And as I say, I'm very concerned that in the impending and I would say imminent impending renegotiation of CUSMA, this will be an item that'll come up quite quickly on the agenda, and I think needs to be addressed. So addressing your responses both in the letter and in substance, I think is imperative, and the advice that Stephen and others are giving to you is extraordinarily important at this window where we can still be much more responsive to the preamble of the substance of pith and substance of the bill itself. So let me turn it back to you, Stephen. And
Oh, thank you very much, John. I really appreciate your insights, and thank you, Senator Miville-Dechêne. And just to supplement John's comment about the number of seizures at the U.S. border, since the Uyghur Forced Labor Protection Act came into force in the U.S. in June of 2022, 15,539 shipments have been detained at the border, the value of 3.66 billion American dollars. So that just a little context in terms of what's going on south of the border. What's coming next for Canada? The government 2024 fall economic statement announced the government's intent to introduce legislation to create a new supply chain due diligence regime, and also announced their intention to introduce legislative amendments to strengthen the ban on imports of goods produced with forced labor. So those are coming. I thought I would take a minute to just explain what a due diligence regime is. In Europe, there are, and stemming from the United Nations guiding principles, in France, there's a duty of vigilance. In Germany, there's a German Supply Chain Act. There's other legislation that's called human rights due diligence legislation. And the due diligence that's being referred to is somewhat different than the way many people in North America interpret due diligence as being an inquiry, an audit, to confirm a given set of facts. But when we talk about human rights due diligence, which is what the federal government was getting at, we're talking about something different. And I thought I'll give you an example by referring to a bill, Bill C-262, that was in the House of Commons. The first reading was in March of 2022. And this is an example of what due diligence legislation is. It requires businesses to establish processes to prevent, address, and remedy adverse impacts on human rights that occur in relation to their business activities. So that means they have to not just report, which is also included, but they have to develop and implement due diligence procedures to identify and assess actual and potential adverse impacts. And if they find them, they have to cease that activity and take remedial action and mitigate risks of adverse impact. So going beyond just reporting on it, which is what the Supply Chains Act does, due diligence legislation requires companies to conduct their business in a way that ensures that there are no adverse human rights impacts that are caused by the business. And that Bill C-262 also had a private right of action that anyone who alleges they've suffered loss or damage as a result of a failure by an entity to comply with its obligations to prevent adverse impact can bring an action in provincial superior court for damages, aggravated and punitive damages, or an injunction. So in terms of the intention of the government, at least before it was prorogued, to bring forward a due diligence regime, I wanted to give you a peek into sort of what that would entail. I now like to.
Can I add just a little something on
Of
this,
course.
Stephen? Just to give an example with the French law, which is la loi de vigilance, what's important to understand is that those due diligence laws are only capturing the very large companies. In France, we're talking here about 200 companies that have more than 5,000 employees. And if they're have activities abroad. We're talking here about 10,000 employees. So we made the choice, because Canada was really far behind, to start with a more modest law, which is our law, but as John says, transparency on steroids, or with teeth, as I say. We made that choice because we thought that's where we were if we wanted to have more companies understand what's going on and work on their supply chain, as opposed to a more rigid law, which the government wrote about before Prime Minister Trudeau resigned, before everything happened. So we don't know where that is, but it's very true that the idea of going towards due diligence was written, and the rest is completely out of our hands. But in the meantime, I would say it's one more reason to be very serious in respecting S211.
Oh, thank you very much, Julie. Senator Miville-Dechêne. And John, do you have some further commentary?
Yeah, I just commentary on your commentary, just because I was peripherally involved in the discussions in the fall about what's next, and it's a bit of chaos, to be candid about it, because there's essentially three entities in this. Well, I guess there's four. There's the actual border legislation itself, and then there's CUSMA, and then there's Canadian Office of Responsible Enterprise, and there's the National Contact Point, and then there's 211, and then there's this potential due diligence bill. And I'm glad you clarified what due diligence means here as opposed to due diligence means there. My suspicion is that very few people actually would appreciate the distinction, and may not, and not that I would say that anybody in the government of Canada doesn't know what they're talking about, but yeah, there's a remote possibility that that's true. And it is in the context of a government that was on its last legs, and there was no real chance that anything, either regulatory or legislative, would actually get done. So at this point, all of that is just talk. Having said that, it's just talk, or was just talk. I think you have struck the note, Stephen, and as has Julie, that this is got the real potential of taking off if, in fact, the negotiations start on CUSMA as quickly as Trump and, to a lesser extent, Carney wanted to take off, and that, I think, will look a lot more like either the Uyghur supply chain bill or some form of aggression, not only aggression at the border, but a responsibility further into and in depth in the supply chains. So yeah, it's a classic stay tuned, because this is going to be an expanding field.
Thank you, John. And you mentioned the Uyghur Forced Labor Protection Act. That is American legislation, and what is unique about it is that it puts in place a rebuttable presumption that any goods made in whole or in part in the Xinjiang Uyghur Autonomous Region are deemed to be forced labor made goods, and the burden is on the importer to prove by clear and convincing evidence that they were not made with forced labor. And John, and that is what I think was, well, I know was suggested by Marco Rubio to a cabinet minister, Mary Ng, in the fall, was that Canada should adopt a law like the UFLPA.
Yeah, and just to add to the point, Rubio did say that, and my sarcasm would cut in here and say that Rubio apparently has very flexible principles. But the person who doesn't have nearly as flexible principles is Senator Merkley, who may or may not have been also a signatory on that bill. I remember there were 2 Congress people and two senators, not Bill on the letter. And Merkley is a really capable, serious senator who has pursued the Uyghur forced labor legislation. So I did have a conversation with him in his office about a year ago, and we didn't really have a good answer to why Canada's not doing anything.
So, Julie, do you have any final comments?
You're on mute, Julie. Julie, you're on mute.
The situation at the border is very worrisome because we don't want to serve as a dump for goods that are made with forced labor and that cannot enter the US. You can see, as this would be seen, it would go against our values, but it would also create many problems. And there's one case already that has been documented on of a shipment that was rerouted to Canada, finally could not disembark the goods. But this can happen. We're not far, so we have to clean up our act and be stronger at the border, as well as trying to prevent goods made from slave coming in the country. Both laws have a different purpose and are important if we want to be seen as a defender of human rights, because we have talked a lot as a country, but in terms of not only laws but of having laws work, we're not there yet. At the border, it's been 5 years, 4 years, and the number of arrests and obviously it has to do probably with the law as it is written, but also the enforcement of the law. So amendments would be necessary.
Oh, thank you. John, any final comments?
Well, there was a couple of things that I glossed over because I was running out of time. And the first is the state of play for the Canadian Office of Responsible Enterprise. It is has no head at this point, and hasn't been replaced. And it's I think a holding pattern. But it issued, I think, something in the order of 11 reports. Every one of them would have immediately engendered an inquiry under S211. None has been that has not been followed up on. So I don't know how the new government will shape its positioning in this field. We did have conversations about centering on Canadian Office of Responsible Enterprise, allocating the responsibility for this bill to CORE, and presumably working in coordination with CBSA over the border enforcement. And that would all, of course, fall under the broader negotiation of the Canada-US Free Trade Agreement. I'm concerned that we will not be looking at a similar set of, for want of a better term, anemic responses to my inquiries this time next year. That there will actually be substantive inquiries. Hopefully, CORE will be up and running, or some version of CORE will be up and running by then. I expect that journalists will start to hone in on entities that don't comply, either don't comply or have filed reports that are of dubious quality. And I expect that this will be if it's a Carney government, it'll be a fairly business-oriented government, but it will be business-oriented on doing business the right way, and we'll have very little tolerance for this kind of stuff that the bill aims to deal with. So stay tuned. I don't think you're going to be underemployed, Stephen.
Well, thank you very much, John, and thank you, Senator Miville-Dechêne. Really appreciate you taking the time to join us and those who are attending the webinar today. It's been a pleasure, and we hope everyone has a good day. Thank you very much.